guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. I am back with an update on the Lake Brantley M plot. Just got to be careful using that particular word here on the YouTube streets, and especially at the beginning of a video or a live. YouTube's just not fond of it, even though it's sadly an everyday occurrence here in this world. So these two are still in jail in Seminole County. Isabelle Valdez and Lois Lippert. If you are not familiar with this case, I do have a playlist. I will link to it in the information of this video. Basically, Isabelle got her friend Lois involved, and Isabelle was obsessed with Adam Lanza, the high school shooter, and she wanted to attack and unalive or another student because she thought it would bring back Adam Lanza. It's this whole thing, and also the law enforcement, they found CSAM on Isabelle's phone. So out of the two, Isabelle is really got the most problems. Lois seems to be a follower, and she's just kind of an accomplice, but she's still got some really serious charges that she's gonna have to deal with. So yeah. So let me jump in. There is some new stuff. Isabelle is going to be in court on Wednesday, and her attorney is trying to uh, get some of this evidence kicked out of her case. So let's go through that. So this is Seminole Clerk's docket, the Clerk of Court's docket. Isabelle actually has two. She's got two cases in criminal court right now. This one here is the original attempted first degree, the M, and then this is the CSAM. So we will look at that one as well, but this is the one that got her in all of the trouble. Of course, the CSAM, well, that's going to be problematic as well for her. There is a 12-page motion from her attorney to suppress evidence. Now, obviously, her attorney has submitted other sorts of stuff looking for their discovery. They're talking about the motion to continue, that sort of stuff. But this one here is very interesting because the attorney is trying to get a lot of this stuff dropped. And I personally don't think it's going to work, but you guys let me know what you think. Again, as always, I glanced through the document, but I haven't read it in its entirety. So we're going to do that right now. So this is the Circuit Court of the 8th Judicial Circuit in and for Seminole County, Florida. And there's her case number 2026-CF-000265-B. The state of Florida versus Isabelle Valdez. Again, this is the motion to suppress evidence. Comes now the defendant Isabelle A. Valdez by and through the undersigned attorney pursuant to Florida Rule of Criminal Procedure 3.190G1, 3.190H1, the 4th, 5th, and 14th Amendments to the United States Constitution, and Article 1, Statute 9 and 12 of the Constitution of the State of Florida, and moves this honorable court to enter its order suppressing any and all evidence arising out of the illegal seizure, search, and subsequent questioning of Isabelle A. Valdez. Defense shows the following grounds. Now, I haven't researched this yet, but, and of course you guys all know, I'm not an attorney, and I don't play one on YouTube. But I don't think that there's a lot of rights for these teenagers while they're in school on school property. I could be very wrong. So, but when you enter school property, I believe your bags and lockers and that sort of stuff can can be searched. So, you know, because you're a kid. But again, this attorney either way is trying to do everything that they can to help their client. That's what they're always going to be doing. Evidence to be suppressed. Any and all tangible or intangible evidence obtained contemporaneous to and the following illegal seizure, search, and questioning of Miss Valdez, specifically including any and all statements made by Miss Valdez, any alleged confessions, and any and all physical evidence found on or about Miss Valdez's person or property, including any physical evidence located in, on, or about the book bag belonging to Miss Valdez. Standing. Miss Valdez has standing in this matter under the plain language of the Fourth Amendment to the United States Constitution, as well as Article 1, State Statute 12 of the Florida Constitution, as Miss Valdez was illegally seized, searched, and questioned on or about January 23rd, 2026, at approximately 0738 hours. A defendant agreed by an unlawful seizure and search may move to suppress anything so obtained for use as evidence because the property was illegally seized without a warrant. Welch versus State, 741 Southern 2D, 1268, 1270, Florida 5th DCA, 1999. Ms. Valdez has standing to challenge the warrantless and illegal seizure, search, and arrest of her person. A person has standing to challenge the seizure of their body, no matter how the officer chooses to characterize this encounter. See State versus Singleton, 595 Southern 2D 44, Florida, 1992. Additionally, Florida Statutes 901.1516 provide standing to suppress the evidence. Florida Statute 901.1516 states no evidence seized by a law enforcement officer in any search under this section shall be admissible against any person in any court of this state or political subdivision thereof, unless the search which disclosed its existence was authorized by and conducted in compliance with the provisions of subsections 2 through 5. Since law enforcement illegally seized, searched, and arrested Miss Valdez has statutory standing under Florida Statutes 901.1516 to suppress the evidence police obtained unlawfully. I do believe that they had an arrest warrant for her. We're going to go back and take a look at that. And I'm also going to look about what rights that she does have. So we're going to go back and take a look at that after I read this. Burden on the moving party. The moving party on a motion to suppress has the burden of making an initial showing that the evidence at issue was obtained by the government as a result of a seizure or search. Bare allegations set forth in motion unsupported by proof are insufficient to sustain such a burden. State versus Gay, 823 Southern 2D 153, Florida 5th DCA 2002. A showing that a seizure once established was effected without a warrant raises the presumption of illegality, which then shifts the burden to the state to show otherwise. State versus Dodd, 396 Southern 2D 1205, Florida 3rd DCA 1981. This court should take judicial notice of the lack of an arrest warrant in their file. State versus Hinton, 305 Southern 2D 804, Florida 4th DCA 1975. Reservation of the right to request judicial notice. Pursuant to Florida Statute 9.202 through 204, 2026, the defendant notices the state that it's reserving the right to request the court to take judicial notice of the absence of any arrest or search warrant in this case file, or of any arrest or search warrant having been filed with the clerk of the circuit court in respect to the offenses for which the defendant is charged. See also State versus Hinton, 305 Southern 2D 804, 807, Florida 4th DCA 1975. holding courts may properly take judicial notice of the contents of the court file in a case on a motion to suppress. Reservation of the right to invoke adverse witness rule. Pursuant to Florida Statute 90.6123, 2026, the defendant reserves the right to call as an adverse witness any person listed on the state of Florida's witness list or otherwise identified with the state of Florida and to interrogate them by leading questions. Reservation of the right to amend this motion or tennis. The defendant via counsel would like to request the court's leave to amend this motion at any time during the pendency of this court's jurisdiction of this cause. The defendant reserves the right to present appropriate case law and argument at the time of hearing in this matter. Facts. 1. On or about January 22nd, 2026, at approximately 23:30 hours, an anonymous tip was received through get45florida.com, directed to appropriate law enforcement agencies and school officials at Lake Brantley High School. 2. The tip read, "A 15-year-old friend of mine who is trans with a preferred name of Jimmy told me that he's going to kill somebody we know from the school by the name of Redacted. He stated that he would do it tomorrow. This happened just about a couple of hours ago. I have a great suspicion that he would do this as he already has been recently involved with police officers at school about threats we've been getting towards our school. He knows the people who have made the threats and the cops are also aware of this. He has also told me earlier today that the cops have confiscated his phone as they got another threat, which apparently was one of the reasons why he wants to do something like this. I am not sure about Jimmy's legal name since I never call him by his legal name, but by memory it might be Isabelle." 3. On or about January 23rd, 2026, at approximately 0510 hours, MPO J. Danis, hereinafter MPO Danis, a school resource officer for Lake Brantley High School, was made aware of the anonymous tip. 4. Shortly thereafter, MPO Danis notified the Altamont Springs Police Department Investigation Section Watch Commander Lieutenant A. David, hereafter Lieutenant David. 5. At approximately 0600 hours, Seminole County Sheriff's officers are dispatched to Miss Valdez's home. 6. During this visit, sheriff's officers spoke with Miss Valdez pertaining to an investigation, to which Miss Valdez denied speaking to anyone the previous night or having the ability to contact anyone due to law enforcement possessing her phone. 7. At approximately 0:33 hours, Lieutenant David informed Detective G. Funk, hereinafter Detective Funk, and Detective L. Church, hereinafter Detective Church, about the planned attack. 8. At or about 06:53 hours, Detective Church contacted MPO Danis, who informed him that Seminole County Sheriff's officers had gone to Valdez's home, as well as her responses to the questions asked. 9. Detective Church then directed MPO Danis to pull Miss Valdez and her best friend, Lois Lippert, from their classes because he would be responding to the school to conduct interviews. 10. Shortly thereafter, Detective Funk, Detective A. Hippler, hereinafter Detective Hippler, and Detective Church met at Lake Brantley High School and were briefed by school officials and MPO Danis. 11. At or about 0:36 hours, MPO Danis informed Redacted, hereinafter Redacted, Lake Brantley High School that Miss Valdez was at the school. 12. At or about 0:38 hours, Redacted contacted Mike Mitchell, hereinafter Mitchell, Lake Brantley High School security guard, requesting that Miss Valdez be brought to her office. 13. Upon arrival, Redacted noticed that Miss Valdez did not have her backpack, and she requested from Miss Valdez's teacher that Miss Valdez's backpack be brought to her office. 14. Redacted then began speaking with and questioning Miss Valdez while a law enforcement officer was present in Redacted's office, to which Miss Valdez complied with the questioning. 15. Redacted then utilized Miss Valdez's answer to the questions to pass information on to law enforcement officers who continued the investigation. Law and argument. A. Fourth Amendment in Article 1, subsection 12, Florida Constitution. The Fourth Amendment of the United States Constitution in Article 1, subsection 12 of the Florida Constitution states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. United States Constitution, Amendment 4, Florida Constitution, Article subsection 12. B. Illegal seizure of Miss Valdez's person. A Fourth Amendment seizure of a person requires the use of force with intent to restrain. The seizure of a person can take the form of physical force or a show of authority that in some way restrains the liberty of the person. A seizure by acquisition of control involves either voluntary submission to a show of authority or the termination of freedom of movement. See Torres versus Madrid, 592, United States 306, 318 through 19, 2021. Seizures deprive an individual of control over their person or property. Horton versus California, 496, United States 128, 1990. A seizure occurs when, under these circumstances, a reasonable person would believe that they are not free to leave or otherwise able to terminate the encounter. RA versus State, 355, Southern 3D, 1028, Florida 3D, DCA 2023. See also United States versus Mendenhall, 446, United States 544, 1980. In the above styled case, Miss Valdez was seized for Fourth Amendment purposes the moment she was removed from her classroom by Mitchell and escorted to redacted office. Miss Valdez's liberty was restrained as she was not able to walk herself, nor was she able to decline the demand to see redacted, given that redacted Miss Valdez's submission to her and Mitchell's show of authority, by definition, meet the criteria to classify this interaction as a seizure by acquisition of control. When a seizure occurs, the Fourth Amendment requires consideration of the totality of the circumstances. Villanova versus State, 189, Southern 3D, 982, Florida 2D, DCA, 2016, GM versus State, 19, Southern 3D, 973, Florida 2009. Some factors which the court have considered when determining a person has been seized by law enforcement are the threatening presence of several officers, the display of a weapon by an officer, some physical touching of the person, of the citizen, or the use of language or tone of voice indicating that compliance with the officer's request might be compelled. State versus KF 333, Southern 3D 362, Florida 1st DCA 2022. DT versus State, 87, Southern 3D, 1235, Florida 4th DCA, 2012. The appropriate inquiry into whether there has been a seizure of a person is whether the challenged conduct objectively manifests as an intent to restrain. Courts rarely question the subjective motivations of law enforcement officers. Miss Valdez was seized the moment Mitchell, the Lake Brantley High School security guard, removed her from her classroom and directed her to go with him to redacted office. Although Mitchell is security guard for Lake Brantley High School, he was acting under the direction of Redacted, who in turn was acting under the direction of law enforcement officers, specifically Detective Church. Detective Church's demand to MPO Danis to seize and secure Miss Valdez demonstrates law enforcement's control of the ongoing investigation. At no time was Miss Valdez free to refuse to go with Mitchell, neither was Miss Valdez free to leave redacted office, nor was Miss Valdez ever informed that she was being investigated. After arriving at redacted office, Miss Valdez was not informed she could go back to class, nor were her parents contacted until hours later. And Miss Valdez was not informed she was under investigation. Miss Valdez's understanding of the investigation, as well as her parents being informed as to what was occurring, took place hours after she had been illegally seized and detained. Upon Miss Valdez arriving at redacted office, the door was closed with redacted any law enforcement officer present in the enclosed room. Redacted, then noticing that Miss Valdez did not possess her book bag, reached out to Miss Valdez's teacher and demanded the retrieval of Miss Valdez's book bag to Redacted office. In addition to being illegally seized, due to her restrictions in movement while in the presence of a law enforcement officer, the seizure is further demonstrated by obtaining domination and control over Miss Valdez's book bag and personal effects located therein. Similar to the facts in Florida versus Royer, in which the court stated that retrieval and possession of Royer's luggage made it clear that Royer was not free to leave. 460 United States 491, 1983. C. Fourth Amendment protections in schools. Searches by public school officials implicate Fourth Amendment interests. Board of Education of Independent School District number 92 of Potawatomi County versus Earls, 536 United States 822, 2002. Thus, in carrying out searches and other disciplinary functions pursuant to school disciplinary policies, public school officials act as representatives of the state, not merely as surrogates for the parents, and they cannot claim the parents' immunity from the strictures of the Fourth Amendment. New Jersey versus TLO 469, United States 325, 1985. D. Acting as agents of law enforcement, seizure requires probable cause. Where a law enforcement officer directs, participates, or acquiesces in a search conducted by private parties, that search must comport with the usual constitutional standards. Thus, where a law enforcement officer directs, participates, or acquiesces in a search conducted by school officials, the officer must have probable cause for that search, even though the school officials acting alone are treated to a lesser constitutional standard. AJM versus State, 617 Southern 2D 1137, Florida 1st DCA 1993. Referring to State versus DS, 685 Southern 2D 41, Florida 3D DCA 1996. MJ versus State, 399 Southern 2D 996, 1981. Detective Church directed MPO Dennis to pull Miss Valdez from her classroom because Detective Church would be responding to the school to conduct interviews. This demand, occurring after the fact that Seminole County Sheriff's officers had already spoken with Miss Valdez at her home, established that the actions taken by school administrators were at the behest of law enforcement and not simply for school disciplinary functions. These actions are further cemented when Redacted contacted Mitchell to bring Miss Valdez to her office. At no point would a reasonable 15-year-old student at Lake Brantley High School with no prior criminal history, school disciplinary records, nor understanding of the legal proceedings and protections believe that they were free to leave, nor would they believe that they had free will to decline the demand of being summoned by Redacted. We need to look about her history because I had a feeling that she might have had some juvenile history, but see, that may be difficult to find out too, though. E. Detectives lacked probable cause because they relied on an uncorroborated, anonymous tip. The courts have identified a reliability scale as it pertains to tips provided to law enforcement. On the low end of the scale are anonymous tips provided by citizen informant tips, with the high end of the reliability scale being confidential or known informants. The United States Supreme Court has held that, unlike a tip from a known informant whose reputation can be assessed and who can be held responsible if their allegations turn out to be fabricated, Florida versus JL 529, United States 266, 2000, an anonymous tip alone seldom demonstrates the informant's basis of knowledge or veracity. Navarrete versus California, 572, United States 393, 2014. Florida versus JL 529, United States 266, 2000. Knox versus State 296 Southern 3D 989, Florida 1st DCA 2020. Standing alone, an anonymous tip does not justify an investigatory stop. State versus Quinn 41 Southern 3D 1011, Florida 5th DCA 2010. When a police officer acts on an informant's tip, the reliability of the information must be established before the officer can make an investigatory stop. Wallace versus State, 964, Southern 2D, 722, Florida 2D, DCA 2007. Some tips, completely lacking in indicia of reliability, would either warrant no police response or require further investigation before a forcible stop of a suspect would be authorized. State versus DeLuca, 40 Southern 3D 120, Florida 1st DCA 2010, because an investigatory stop is not justifiable on an uncorroborated anonymous tip. A seizure based on such is an outright flagrant violation of the Fourth Amendment's protections afforded to individuals, including students. It is uncontradicted that the tip received from Fortify Florida was indeed an anonymous tip. The individual that submitted the tip could have signed their name prior to submitting said tip, but made the conscious and deliberate decision not to do so. The tip did not list any specificity, nor did the tip present any form of reliability. The tip at best relayed generalized information. Law enforcement officers arriving at Miss Valdez's residence the morning of and questioning her should have dispelled any concerns presented by the allegations due to her denying having communicated with anyone the evening prior and admitting to not having a device to do so. Law enforcement officers were well aware that someone had been targeting Miss Valdez with false reports of swatting at school. The fact that should have increased skepticism toward other anonymous accusations rather than decreasing it. This I completely disagree with. Can you imagine, though, if they didn't take this anonymous tip seriously? The awful thing that could have happened to that other student. F. Fruit of the poisonous tree. In Mapp, the court held that the Fourth Amendment bars the use of evidence secured through an illegal search and seizure. Mapp versus Ohio, 367, United States, 643, 648, 1961. Therefore, evidence obtained during or as a direct result of unlawful police conduct is barred by the exclusionary rule. Wong's Son versus United States, 371, United States 471, 484, 1963. Suppression of any and all evidence is required due to the illegal seizure, search, and questioning of Miss Valdez. Wherefore, Miss Valdez respectfully requests this honorable court enter an order suppressing any and all tangible or intangible evidence obtained contemporaneous to and the following illegal seizure, search, and questioning of Miss Valdez, specifically including any and all statements made by Miss Valdez, any alleged confessions, and any and all physical evidence found on or about Miss Valdez's person or property, including any physical evidence located on, in, or about the book bag belonging to Miss Valdez. And certificate of service is signed by, looks like her attorney is Edward Lopez Esquire. So that is where that stands. I need to do some more research on this, but of note, Isabelle is due back in court this week, so Wednesday, August 5th. And I believe Lois is not due back until September. Let me just glance over at hers. I think her next court date is September. Yeah, September 2nd. So they're both due in September 2nd, but Isabelle is due in this week for a docket sounding at 9 a.m. And I know that from what they're stating that her attorney is trying to see if the state will work with Isabelle for some sort of a plea deal. I I don't know if that's gonna happen, considering all the additional CSAM charges and such. I would think that Lois Lippert might have a chance of a plea, but I don't know. I mean, I don't know about Isabelle. What do you guys think? Now, as far as search and seizure in the state of Florida involving, students, they obviously, her lawyer, when they filed the motion, had referenced the Supreme Court Jersey versus TLO, the 1985 landmark decision of New Jersey versus TLO, holding that the search provisions of the Fourth Amendment to the federal Constitution apply to school officials. School officials, however, would be held to a reasonable suspicion standard rather than the probable cause standard required for law enforcement. So the school, they have to deal with like less um, reasonable suspicion that they could search her bag. Okay. But what the attorney is stating here, it looks like that because law enforcement was involved, that they needed a warrant, probable cause, some sort of, filing. I know there was an affidavit. I don't know when exactly that was filed. I'm gonna have to look that up. But because they were acting, the school was acting behind law enforcement. That's why the defense attorney here, Lopez, is trying to get this all tossed because of the New Jersey versus TLO case. And it's amazing how these older cases really do continue to, come into play here in 2026. Again, so the school officials don't need probable cause to justify a search of a student as long as the official is not acting at the behest of the police. So this is where the line is a little blurred. So that's what her attorney is stating, that because the police were there, it was at their bequest that they searched her bag, which I guess I can see that. As far as, did law enforcement have probable cause? I'm hoping they had all their ducks in a row. As far as this is concerned, I mean, I feel like the tip was legitimate. And when they're also stating that Isabelle did not have a history of any issues, I think they're leaving out some things. Her attorney is in this motion as well, because I think that Isabelle has had quite a bit of run ins with some problems in school and potentially law enforcement. I think that those swatting calls were probably involving her. But we shall see, what the judge has to say about this motion to suppress um, her being detained in her backpack. Um, Hopefully, like I said, hopefully law enforcement, the sheriff's office, Altamont Springs Police Department, hopefully they got all their probable cause and their documentation that they needed to do that search. I really hope that they did. So let me know you guys' thoughts on this one. Like I said, the whole motion thing, trying to um, get rid of the search, uh, obviously pulling her in there, searching her bag. I'm hoping like I'm hoping again that this is just the attorney trying to obviously protect his client, do his job, but it does sound like there's some legitimate questions as to if the school was following law enforcement's orders, and law enforcement did not have everything that they needed, legally speaking, to do that. And as to, will Valdez get a potential plea deal? I don't know. I mean, Florida has been kind of handing out plea deals, it seems like, these days. And definitely in Orange and Osceola County. I don't know what the record is over there in Seminole County. Um, I don't know. I mean, I'm kind of on the fence on that, if she should get a deal. She's obviously claimed in her letter, we previously went over, that she's got a lot of issues, mental health issues, and I do think that that's true. I don't know, we don't know what else is going on at home, so I don't think that they're not going to give her any sort of time, or have to, or she may have to be put in some sort of program, in a mental health home, or that sort of thing. uh, and then as far as Lois is concerned, her attorney hasn't filed much of anything, so I could see her potentially getting a deal. but I think we're going to know more later this week, and definitely we'll know more about where things are going by the beginning of September. All right, guys, I hope you have a great rest of the day, and most of all, stay safe.